Well, good afternoon, everyone, and thanks so much for coming along to session 2A, Legal Representation, Legal Aid and Information. We've got a fantastic panel to follow on from this morning's session, so let's get started. So our session this afternoon will explore legal representation, legal aid and information. In particular, we'll look at access to legal advice and representation and changes in the legal aid landscape, as well as how legal advice and legal representation work together and how this can be most effectively achieved. So both Susan Reardon-Smith and Emma Marshall and all the Refugee Law Initiative volunteers have lots of experience of working in law clinics, and Maria Bazdecki and Martha Hatzinotunio are both lawyers in Greece. So I'm sure this is going to be a really grounded and rich session. So thank you all for sharing your work with us. But up next, we have Emma Marshall, who is a part-time postdoctoral research fellow at the University of Exeter and a research fellow at Public Law Project, who are a national legal charity that works to improve access to justice. Emma has recently completed a really fantastic PhD on the British legal aid system, including the exceptional case funding scheme, particularly in relation to immigration and asylum matters. And as part of this doctoral research, Emma set up and ran an exceptional case funding clinic at the University of Exeter, and she's currently working on a project to establish a policy clinic within the law school. So I'm really excited to hear more about Emma's work today, and I'll hand over to you, Emma. Thank you.
Thanks so much, Jo, and that was really a moment of truth because I've had to move laptops following slight tech issues. So I'm hoping now that I can get my presentation up on this one. Great, thanks. So thanks for the introduction. I'm slightly worried I might have gone too conceptual in this, so please bear with me. It occurred to me as I was writing this to match my title that actually there's a bit of a practitioner crowd here, so I hope it's useful. I'm sorry because I'm now reading the screen above the camera, so I hope it doesn't look too odd. So I think firstly I just want to say that I'm not a lawyer myself, and my background before doing my PhD was working for a refugee community organisation. So I completely recognise the need for a whole range of organisations to exist providing support who aren't lawyers, but I also think in the context of immigration there are really important reasons that people do need access to specialist legal advice. And I'm hoping that this will kind of build a bit on what we've already heard from the Refugee Law Clinic. So in this presentation, I'm going to give some thought to some underlying assumptions about the need for immigration advice by focusing on what happens when people aren't able to access the advice that they need and when they need it. So I'm going to talk a bit about my sort of conceptual thinking around how we think and talk about luck in processes of asylum determination. And then I'll talk about some of my findings in my PhD research in terms of practical engagements in the politics of legal aid provision in the UK. And I also wanted to say that this presentation isn't specifically about representation within the tribunal, but more around thinking about how structures of the asylum process and the regulation of advice influence how cases kind of progress. So if I can get the next slide. So the metaphor of luck is really common in discussions about the asylum process. I've kind of pulled out a few examples that you can see here, which include media coverage, NGO resources, and academic work that kind of engage with this language of luck. But in terms of academic discourse, there's been a lot of discussion about the lottery of asylum adjudication and the factors that determine outcomes of judicial decision-making. So a key example of this is an article from the US, which was published in 2007, titled Refugee Roulette, Disparities in Asylum Adjudication, which was later developed into a book with various chapter contributions from other authors, which is the picture here. And the academics that worked on the Refugee Roulette article looked at differences in outcomes across hearing centres. So this is the idea that the outcome that you might get within the asylum process is kind of spatially contingent on who hears your case and where it's heard. And this is a really important point about fairness, but it also raises a question about the significance of the sort of effects of legal representation on experiences of legal process. And that's really exemplified in in this report by Bail for Immigration Detainees from July 2010, with this quote, "It's horrible, isn't it, thinking you want a nice judge on a good day," which informs the title of the report. And one of the things the report highlights is the difficulty of accessing good quality legal advice from detention. So I'm going to work a bit backwards here to flip it, to consider why, if you don't want systems of immigration decision making to fall to having a nice judge on a good day, then what you might need is a good lawyer at the right time and the consequences when that isn't possible. So first of all, I want to make a distinction between two different ways of speaking about luck. So the first is luck as an experience, and this is what Martha Nussbaum is speaking about here in her work on Greek ethics, which, to paraphrase, is not about events that are random or uncaused, but what happens to a person not through their own agency. So luck here is experiences that are beyond an individual's own control. And this is really significant when talking about experiences of asylum, because refugees themselves often might want to talk about their experiences as luck, which is completely legitimate. And so I'm going to term what we're talking about here as experiential luck. But I also think it's important to make a distinction with what is meant by luck in a broader sense. So as events that are random or uncaused, or what we might term as pure luck, because these are much rarer circumstances that no one has any control over. And this is important because asylum determination processes are designed and implemented in ways that mean uneven outcomes might be outside of individual control, but they're not outside of human control or our collective control as societies, and that they're not entirely at random, they're influenced by structural factors. So I just want to footnote a podcast I listened to a few years ago that kind of helped me to really think this through, because I've been thinking about the concepts of luck and class in relation to asylum processes. And the podcast isn't about asylum, but it was a discussion about the work of an American economic liberal theorist, Robert H. Frank, who was talking about the effects, talking about the effects of luck as a critique of meritocracy. So the other discussant was a theory of class, Lindsay Hanlon, and she observes that the luck that Frank talks about has a structure. And this really made me think a lot about the structure of luck within the asylum process and the role that access to legal advice plays in influencing people's experiences. Partly because there's an inequality between those who can afford to pay for legal advice and those who have to rely on the legal aid system in the UK. But there's also something about how systems are structured in ways that influence particular outcomes, not just in terms of the tribunal process itself, but who ends up there. So in his book, Robert H. Frank talks about his theory of luck being based on his own experience of having a heart attack and being lucky that an ambulance was nearby to save his life. But there's some structural conditions that have to be in place to facilitate the possibility of luck in this instance. So for an ambulance to be nearby, there has to be healthcare infrastructure, and this in itself relates to wealth because there's an inherent privilege of living in a wealthy area with good healthcare. So in this way, experiences of luck might also be closely related to experiences of privilege. And I don't want to go too deeply into this because there are lots of reasons for not wanting to talk about asylum systems in terms of privilege, particularly in the ways that people are treated very poorly often, and if contrasted with elite forms of mobility, it's certainly, asylum isn't a privileged form of movement, although there might be relative privilege in who gets to move. But what I really want to draw attention to is the fact that, sorry, there's a Sainsbury's van outside. It's not too noisy. What I want to draw attention to is that there are reasons why we might want to reject the luck narrative in thinking about asylum outcomes, because discourses of luck can operate to conceal structural differences in material wealth and reduce or shift accountability by making events that appear to happen beyond human control, and when it's actually not the case. So we might want to think about outcomes as beyond the control of individuals within the asylum system, but not our collective control as a society. And my final conceptual point is that in the title of my presentation, I use the term structural injustice, which is a term used by the American political theorist Iris Marion Young, And I think this is really relevant because Young uses structural injustice to describe the range of influences that produce injustice within a society. And in her work, she's speaking specifically about the US, but she defines structural injustice as the harm that people face as a result of the normal actions of a large number of agents. And what I think is really interesting about this understanding is that it produces an image of the way that different chaotic components of everyday life within a society can work to produce injustice. But the question that she poses in her work on this is how moral agents as individuals and collectives think about their responsibility in relation to the everyday social harms that are caused by these structural processes. And so now I want to bring this back to the sort of specific context around immigration advice provision through the legal aid system in the UK, because I would say that acknowledging that uneven outcomes are not just random within the asylum system, but produced by structural factors such as legal aid is a really important part of our collective political responsibility. And for me, this also raises the question of what can be done to improve things. And it's in this element of thinking about levels of control over various factors within the system that I want to come to. So we've already heard about LASPO. Sorry, I've forgotten a slide. Skip to that one. So we've already heard about LASPO, the Legal Aid Sentencing and Punishment of Offenders Act 2012, and some of its effects. But essentially it made sweeping cuts to the British legal aid system. And at the time it was developed by the government in the UK, there was an explicit agenda of austerity and the reduction of public expenditure. So in the area of immigration, a handful of types of cases remained within the scope of legal aid, including asylum, but everything else which had previously been in scope became out of scope under the Act unless it was specifically stated as remaining in. And everything outside of the scope of legal aid is now accessed via the Exceptional Case Funding Scheme, or ECF, which requires a separate application process that either lawyers can go through or individuals. So in these cases where a person's human rights would otherwise be breached, they should be eligible for ECF under the scheme. But the scheme's been really problematic. It was almost impossible to access when it was first introduced, and it's still a really complex application process. So it's now improved a bit as a result of litigation, and the number of applications and grants through the scheme has gone up over time, but essentially it still isn't operating at the level that the government at the time anticipated it would when they introduced the legislation. So whilst I was doing my research, the people I spoke to often struggled to find good quality immigration advice, which had a range of knock-on impacts in other areas of their lives. So from the stress that they experienced to precarious accommodation, debt, health problems, a range of other factors. I spoke to individuals and organisations in the southwest of England over a period of just under a year and interviewed 21 people in the first stage of my research, which involved speaking to people about why they needed immigration advice, what the need was, what happened when it wasn't available, as well as sort of possible ways that it could be improved. And I want to highlight 3 key points really about this. So firstly, the immigration rules in the UK are incredibly complex. Advice is very highly regulated, and often specialist advice is the least available type of advice, but is really essential for unpicking complex cases. And so these factors work together to exacerbate the risks that individuals face. And I'll come back to this, hopefully I've got time. Tell me, Joe, if I am running short. So when I was doing my fieldwork in 2016 and 2017, there was really limited asylum and immigration advice provision in the southwest, with one legal aid provider able to take on cases in Devon and Cornwall, and the situation hasn't improved really since then. So work by Jo Wilding has also highlighted this issue of immigration legal aid deserts in England and Wales, and this is her map, which just shows how some of the different areas compare. So the area I'm talking about is in the bottom left, highlighted in sort of reddy orange colour, with one legal aid provider, and the grey areas have none. So this is a sort of close-up of that. So this is a map that just shows the area in more detail. So you can see the orange circle is Plymouth, where the one legal aid provider is based. and I've sort of highlighted the triangle around Exeter, which is where I am, and the organisation that I developed my research with is based. So, so this causes problems. The sort of distances in the region between advice, partly because this provider doesn't have capacity to take all the cases to the region. So some people end up travelling further up the map to Bristol, in the top right, but partly because even if they can take on people's cases, it still requires quite significant travel. So people in Exeter are at least an hour away from Plymouth by public transport, and it's further to get up to the top anyway, to Bristol. So I spoke to people who had managed to access legal aid, but then were guided down a route of applying for asylum sometimes, because that's where legal aid was available, only to find at a later stage that their claim could have gone down another route. There were also occasions when people received private immigration advice where they should have been making an asylum claim, but weren't advised to do so, and other cases where people paid for immigration advice even though they couldn't afford it and may have been eligible for ECF. So this raises complex issues because in some cases there is an element of poor Home Office decision making, by them processing claims through one route where they should have really recognised another type of claim would have been more applicable. But there were also issues about the quality of legal advice and sort of the ethical approaches of advisors. So it's difficult for individuals to distinguish what had gone wrong or the motivations of individual advisors, but it was clear that the cuts to legal aid combined with the highly regulated sector meant that when things did go wrong, individuals were either unaware that they could make a complaint or they felt unable to because the situation that they were in, and they had no one else to turn to. So another important point was that sometimes it was only in a case going to tribunal that the person would be able to access the kind of specialist expertise of an immigration barrister, and that they would actually get the correct advice. And so I want to give an example of how that availability of advice can shape who gets to the tribunal. So one man I spoke to, who I'll call Ali, was a refugee from Iran. It took him 11 years to get refugee status, and he had about 7 years of that without legal representation. Eventually he found a legal aid solicitor, but they were in London and he needed a London address to access them. And eventually, when his case went to the tribunal, he won. So another noticeable outcome of the lack of legal advice was pressure on other services. I've got a quote, so this is what one member of staff at a community organisation said. She says, I haven't got knowledge or qualified to give legal advice, so even though there are sometimes forms that you know they could be completed with help, the client only needs someone to help them completing the form because they might not be very confident, or it's a form with instructions. So if you were going to apply, you would do the form, but because they are regulated, you say, sorry, I can't help you, and those are the limitations and frustrations. And because of the regulations around the provision of immigration advice, this also puts people in really difficult positions where they're having to navigate between helping people as best as they can without overstepping into the realms of providing regulated advice, which they're not qualified to provide and which is a criminal offence. So where legal aid is unavailable, it has the kind of potential to also contribute to the criminalisation of those who help asylum seekers, which is referred to elsewhere as crimes of solidarity, because it creates this dilemma between knowingly leaving someone who's in a difficult situation or potentially breaking the law to assist. And without legal advice, individuals also face exacerbated levels of risk, and this was really compounded as well by the hostile environment policy discourse in the UK, which isn't specifically about asylum, and it was brought in just after LASPO, but actually the language of hostility is significant because it has broader effects than those intended. And I often saw how the absence of legal advice that people experienced added to how that hostility was experienced and felt at an individual level because they felt unable to challenge their situations, including where they were receiving poor advice. So here are the words of one refugee I spoke to, who I'll call Mohammed, when asked what difference he thought it would make if access to advice could be improved. He says, it would make a huge difference because, for example, a case where someone was given the wrong advice and applied for the wrong application, as a result everything is delayed, and the hardship people live in when they can't work or access benefits just because of a mistake done, so wrong advice being given to them. So if advice is accessible, especially legal advice, so it's accessible and free. It makes people's lives much, much easier, and it would save a lot of time and pain for everybody. I think that's really true. And so just to kind of wrap up, this thinking about improving things led me to being involved with setting up a clinic to support people with ECF applications at the University of Exeter. I've written a couple of things about it if you want to go and have a look. But it also led to this toolkit to sort of support the development of other projects. Because applying for ECF not only helps people to get legal aid, but it also pushes the responsibility back onto the British state to be providing advice where it's kind of been taken out of scope. So some concluding thoughts. If we think about the overlapping effects of austerity and significant reduction of immigration legal aid in the hostile environment, this indicates something more structurally rooted than just the effects of luck or a roulette. So the people I spoke to sometimes described their outcomes as a matter of luck, but the situations that they faced were definitely not a matter of chance, but a matter of structural injustice. And something that still troubles me is hearing people say that we need to look to alternatives to legal aid, basically because it's already gone and it's probably not coming back. But a bit like the luck narrative, I really think that this provides quite a fatalistic view of the system that suggests that we have no control over it. And the reality is we do have collective control and responsibility over how the immigration system and the legal system operate. And whilst we as individuals might not have direct control over certain aspects of the system, we're not talking about random events, but structured forms of injustice that produce these uneven effects, sometimes with at least some degree of intention. So this is why I think Iris Marion Young's work has much to offer in providing an ethos of a politics of responsibility, where we hold to account the causes of injustice and collectively work towards something better. And if there's one takeaway point that I have from this, it's to make sure that we then formulate our discussions of these issues in ways that articulate accountability, hope, and control. Thanks so much.
Thanks very much, Emma. I think that's a really, really helpful intervention, how we think about the different variables that affect immigration and asylum cases. And yeah, the idea of a structure of luck is really, really interesting. So thank you. So our final presentation in this session will be a recorded one from Maria Bazdecki and Martha Hatzianutu. Maria has been practicing law since 2014 and is currently working for the NGO Solidarity Now in Athens as a lawyer for vulnerable groups, including refugees and asylum seekers. She works with Martha, who also works as a lawyer for Solidarity Now in Athens, providing legal consultation and representation. Martha holds a doctorate and has been practicing law since 2000, developing a particular expertise in LGBTQI asylum cases for both first instance cases and appeals.
Good afternoon, everyone, and welcome to our session. First of all, let me thank you for giving me the opportunity to share today's contribution with you. Let me introduce myself. My name is Maria Bazdecki. I work as a lawyer in Greece and my focus is refugee law. My colleague Dr. Martha Hatzianutu, with whom we have prepared today's presentation, could not be here with me due to other commitments. As you can see on the screen, our topic today is focused on second instance asylum cases in Greece, and by the end of this talk, you will be familiar with the current situation of legal representation of such cases in Greece. We thought it would be useful to divide the talk into 4 main sections. The first section is all about the key elements of high-quality legal representation in the preparation of second-instance refugee cases. We will then examine whether these elements are met in practice, and in the third section we will highlight the practical obstacles that are faced during legal representation. These are followed by statistics and figures that shed light on the level of quality of legal representation. We will then end by making useful propositions for the improvement of legal aid. It will take about 20 minutes to cover these issues. First of all, I would like to give you an overview of the current legal framework for international protection applications in Greece. Law 4636 of 2019 on international protection is the main national legal instrument, and it provides for the right of the appellant to an administrative appeal against the first instance asylum decision. In some cases, the appeal has a suspensive effect. The second instance cases are examined by the independent appeals committees, which are either 3-member or single-member. The members participating in the committees are active administrative judges of first instance and of courts of appeal. Based on the recast EU directive, there is a provision for free legal assistance to applicants in appeal procedures before the appeals authority through a registry of lawyers that is drafted by the Ministry of Migration and Asylum. Free legal representation is also provided by some NGOs. As we will see in the following slides, there is a big demand for legal assistance that cannot be covered solely by free legal aid providers. So what are the elements of high-quality legal representation? I will start off by clarifying the actors of the legal aid process, which are the legal representative, the appellant, the asylum authorities, and the decision makers. The relationship of these actors, especially the one between the appellant and the legal representative, must have specific fundamental characteristics that build a high-quality legal representation profile. And these are ethical and professional standards, expert knowledge of asylum law and jurisprudence, up-to-date information, so that the legal representative has the possibility of exploring every reasonable legal avenue and presenting a strong case. Another element is the identification of legal and evidential issues of the asylum case in a timely manner, so that legal arguments are built through the most efficient legal avenue. Additionally, establishing a relationship of trust, mutual respect, the possession of excellent listening skills, all these are elements of vital importance for a qualitative legal representation. Constant interaction with the appellant within a reasonable time frame, not remaining on the basic and typical communication, is also important. Allowing the appellant to have access to the legal reports and to have a word in decision-making is another necessary element. A proactive approach is also a plus to the legal representation, as regular following up, early intervention, and timely submission of evidence may prevent from risky turns to the case, and will definitely minimize the anxiety and satisfaction of the appellant. Finally, sufficient time for legal actions is essential for thorough evidence gathering and for a substantial communication with the applicant, so that the legal representative can make a good preparation of the case's arguments. Through this process, informing the appellant ahead of time and managing their expectations is fundamental. Last but not least, it is imperative to build a constructive relationship with the decision maker for the case's best outcome and for the most accurate assessment of the case. We'll now move on to see when the previously mentioned elements are not met. So, HQ legal representation is not provided when the advice provided to the appellant is inadequate. When, for example, legal information is confused with legal advice and is provided even by actors that are not competent to provide such advice, for example, by the employees of the Asylum Service. When time limits are not met due to factors that are not always attributable to the appellant or to the legal representative. Also, when the legal work done is not extensive, when the individual circumstances of the case are overlooked, and the legal strategies employed do not aim at the best outcomes. We also have poor quality representation when the relationship with the appellant is of poor quality as well and covers only basic communication. When there is a delay in progressing matters, and when there is lack of care and reasonable skill. All the above constitute detrimental service to the appellant and poor legal representation of the asylum case. Such characteristics in legal counseling and representation render them of no value and may even endanger an asylum claim. We'll now have a look at the free legal aid providers in Greece, which, as we mentioned, are the Ministry's free legal aid scheme and some NGOs that provide legal assistance. Until March 2021, the Ministry's registry included only 37 lawyers for the whole Greek territory, and the NGOs providing legal assistance in the second instance are very few in the mainland as well as in the islands. Also, due to limited capacity, the NGOs have to filter down the cases that they undertake. So, as we can see, while the free legal aid providers are few and the number of demands remains very high, we realize that legal representation by state actors and NGOs faces the first and most important obstacle of having to assist too many appellants and being forced to reduce quality in order to assist as many appellants as possible. In April 2021, the Free Legal Aid Registry was completed by 63 more lawyers. This is a hopeful development that free legal aid may start presenting better quality legal representation, but we are still far from the ideal picture of high-quality legal representation in each individual asylum case addressed to free legal aid, provided either by the state or by NGOs. We'll now go on to highlight what we see as the main practical obstacles faced during legal representation. Firstly, regarding service of negative first instance decisions, there is the option of fictitious service by the authorities. Through the fictitious services of decisions, it is highly possible that the appellant is not promptly informed of the rejection, and the deadline for the submission of appeal may expire without the appellant being actually informed about the decision, for reasons again not attributable to them. In such cases, the legal representative can submit an appeal after the deadline, but the appeal may be rejected as inadmissible. Then, the international protection law requires that the appeal submitted is based on specific grounds. Appellants often submit appeals without providing the specific grounds of the re-examination request. Therefore, there is again a high chance that the appeal is rejected as inadmissible, even if a legal representative undertakes the case in a later stage before the discussion of the appeal and adds specific reasons to it. This, of course, is a severe restriction of access to the appeal procedure in practice. Moving forward, in order to request free state legal aid, appellants must complete an online application form. The practical problems here is that electronic applications are often overlooked by the regional asylum offices. Appellants are not always informed in a language they understand, and no assistance may be available for illiterate asylum seekers. Another practical issue that may cause loss of precious time for processing the case file is the form of receiving the case file copies. The application for receiving copies of the file is online, but file reception is conducted by a different policy in every asylum office. For example, in the Athens Regional Asylum Office, apart from the electronic application with the attached authorization and the legal ID, an application by post is required. In the Piraeus Regional Asylum Office, until recently, there was the requirement that the legal representative receives the file copies only through physical presence, and the legal representative had to bring a non-rewritable CD in order to get copies of the files, as the office considered electronic mailing of the files lacked GDPR compliance. Now, regarding the day of discussion of the appeal, an obligation is imposed to the appellant to personally appear before the appeals committee on penalty of rejection of their appeal as manifestly unfounded. This is an obligation imposed on the appellant, even if the appellant has not been called for an oral hearing, and we have to stress that this provision has been criticized as a disproportionate measure of punitive nature. For appellants who reside in reception centers in the mainland outside of Athens or in the islands, there is the possibility that a written certification of the head of the reception center is sent to the committee, and by which it is certified that the appellant resides there. However, the extent to which appellants and the administration itself is able to comply with this procedural requirement is questionable, if we take into consideration the great number of asylum applicants that reside on the islands and the mainland, and the administrative burden that the authorities managing the reception centers face. Again, regarding the day of examination, the procedure as mentioned is written. There is the option of invitation to oral hearing when, among others, there are issues or doubts to the completeness of appellant's interview. And although in practice, it is very common that first instance interviews lack completeness. However, in 2020, only 102 appellants were invited to a public hearing. From the part of the decision makers now, a lack of training and expertise appears as an issue. Judges do not seem to be familiar with international and EU legislation that is related to international protection applications. Lastly, it is a common problem that appeals committees do not take into consideration the legal file that the legal representative submits for the purpose of decision making, and this is obvious by the content of the final decision. Now, last but not least, there is a serious delay in the issuance of the decisions by the committees. The law provides for 3 months from the date of the discussion, but in practice it takes more than 6 months for the decision to be issued by the committee. We'll now see the figures in the following charts. The figures shed light on the questionable quality of legal representation and on the reasons behind it. The first chart shows an extremely high number of rejected decisions, that is over 15,000, and just a bit over 1,000 decisions granting refugee status, subsidiary and humanitarian protection. On a percentage basis, from 2016 to 2020, the rejection rates were all over 90%, apart from the year 2019, where the rejection rate was almost 88%, a percentage that is still high. This extremely low recognition rate at second instance is definitely connected, although not exclusively, but to a significant extent, to poor legal representation, due to a variety of obstacles that legal representatives encounter through the preparation of the case file and the support of the appeal. Such obstacles were mentioned in the previous slides. This is definitely to the direct detriment of the appellant, but also to the entire legal asylum system. Here we can see that for 2020, almost 13,000 appeals were lodged. There are no numbers available about the appellants who addressed the state legal aid scheme in 2020, but as we see in the next chart, for the years 2018 and 2019, less than 33% of appellants addressed the state legal aid scheme. The reason why was because they did not have access to it, mainly due to its limited and poor capacity. But what do we mean by limited and poor capacity? Here we can see that the Free Legal Aid Registry for the years 2018, 2019, and 2020 consisted of only 37 lawyers. Their distribution to each part of Greece was uneven. It makes a very negative impression how the scheme had only one appointed lawyer in the island of Lesbos, where thousands of asylum applications and appeals were lodged. As a conclusion, we would say that we are still far from the ideal picture of high-quality legal representation in each individual asylum case addressed to free legal aid, provided either by the states or by NGOs. Finally, we would like to make detailed recommendations that can contribute to the quality improvement of legal representation in the second instance of asylum procedure in Greece. First of all, a clear distinction between legal information and legal advice has to be made, as legal information can in no way replace quality legal representation. When negative decisions are issued, they should be accompanied with the full administrative file of the appellant. And this is, of course, for better time management of the legal representative and to the best interest of the appellant. Also, in all regional asylum offices, the same policies should apply. The deadline for submitting an appeal in every type of procedure should be 30 days and not less, because it is not feasible to submit a quality appeal within a 5-day deadline. Moreover, we urge the establishment of free legal aid in earlier stages of the asylum procedure. This would lead to a more sophisticated case handling by the time the case reaches the appeal stage. We also support the establishment of only 3-member committees. It is more fair to be judged by 3 persons instead of 1, and also the concentration of power to 1 person does not serve the principle of procedural economy. Finally, the deadlines for decision reaching must be met. And I will now thank you for your attention, and I will close this presentation by commenting that the review of the provision of legal representation should be based on the best interest of the appellant, but also of the entire legal asylum system. Thank you very much.
So, great. Well, thanks very much to Maria and Martha for that. Quite a worrying picture they painted, but a very helpful comparison with the UK situation, and particularly helpful recommendations at the end. So Maria and Martha are unable to attend the conference, but if you've got any questions or feedback for them, if so, do please drop them an email, and the email addresses can be found in the conference programme. So yeah, do get in contact if you'd like to.